hear now for the lawyer, for the defendants, for the convicts, Rishi Malhotra with us. Appreciate your joining us, Mr. Malhotra. You tell us. The belief is that because now the affidavit of the Gujarat government has made it clear that it was the centre that cleared the remission, question marks are being raised and accusations of non-application of mind. July 28, the Gujarat government panel clears the file for remission. By 11th of August, the centre has also cleared it. So questions are being raised whether there was application of mind before this remission was granted, or was it granted for political reasons?
Rajdeep, first of all, our apprehensions or our answers have been vindicated by the state of Gujarat yesterday by filing a detailed affidavit. Because don't forget, Suhasini Ali's writ petition only talked about that they had an apprehension that the central government has not given any approval under section 435 of the Code of Criminal Procedure. Now that has been answered very categorically in the state of Gujarat's affidavit that on 11th of July 2022, the central government has also indeed given its approval. So that's point number one. Point number two is that you did ask Suhasini Ali that why did she file a writ petition. You must ask this question first, that who is she to file a writ petition, because that's our preliminary objection from day one, which has been again vindicated in the state of Gujarat's affidavit that there is no third party strangers permitted in a criminal litigation. So therefore they have no locus standi to file a writ petition under Article 32, because which fundamental rights have been infringed against them. And they cannot espouse a fundamental rights being violated.
No, what about, I asked you whether there was sufficient application of mind before the clearance was made. The centre has cleared this file. It's almost unprecedented. In a case of this nature, given the gravity and heinousness of crime, which both the special judge of the Supreme Court has, a special judge of the CBI court and the CBI has put on record, surely that needed to be looked at, the gravity of the crime.
Please understand that in May 2022, the Supreme Court delivered a very categorical judgment. And what does the judgment say? It says that consider the cases for premature release as per the Gujarat government policy of 1992. What this learned trial judge has given an opinion that is based purely and solely upon Maharashtra government's remission policy, which of course prohibits a convict undergoing a rape and murder charges. So therefore, you cannot compare an apple with an orange, because at that moment of time, what was wrongly done was a consideration under the Maharashtra remission policy and not under the Gujarat remission policy. And in any case, there are 7 authorities who have decided for granting remission. It's not only one advisory board. There are 7 authorities under the state of Gujarat affidavit, which has given a positive report that this person deserves premature release for 2 simple reasons.
These persons are seen to have got more than 1,000, they've already got the benefit of more than 1,000 days in parole over this period. These people are accused by Bilkis Bano's family of threatening and intimidating her. These people are those who have not at any stage shown any remorse. These people are linked to a right-wing political group which garlands them, i.e. the VHP. These people are getting this remission in a year where Gujarat is going to the polls. Are you telling me none of these factors operate? None of these influence all these individuals? Many of these institutions that you are mentioning that gave this clearance are being seen as institutions linked to the ruling party in Gujarat.
I'm surprised. You see, 15 years plus these men have undergone. And how do you assume that they have no remorse or they have no right to reform? Number one. Number two, what all this hue and cry that the advisory committee had consisted of some BJP MLAs and all that, please don't forget what is the rule. The policy says that at that moment of time when the cases are considered for premature release, the sitting MLAs have to be in the advisory board. It doesn't matter the sitting MLA happens to be a BJP MLA or it may be a Congress MLA. So by any chance, if a BJP MLA who is a local MLA there, who has to be part of advisory board committee, if he happens to be there, how can you throw color on that it may be a vindicative or some way of...
No, do you really believe that that the BJP MLAs who were part of this advisory panel would necessarily be neutral, given that this was a case which was politically fraught? Don't you think that somewhere, therefore, the Supreme Court has the right to raise these questions?
No. So what do we do? If the remission rule provides for a local MLA to be there, how can they substitute a local MLA with some other MLA and has to be some opposite party? It
Can
could
they
have been
not
Congress
question
MLA.
the alleged non-application of mine?
Absolutely not. Where is the question of non-application of mine? There is a 10-member advisory committee consisting of judicial officers, a session judge, a superintendent of police, a jail superintendent, and of course these MLAs and social workers. So mainly because some of the MLAs happens to be of a one political party affiliation, how do you throw doubt on the judicial officer's mind?
So in your view, you believe that this is a case where there is no question of any attempt being made by the Supreme Court to exercise jurisdiction over the decisions taken by this committee granting remission. Am I correct?
You're absolutely correct, number one. Number two, what has to be seen basically for the purpose of remission is how was the conduct in the jail? Was there any offense committed during the man who was inside the jail? And did he ever avail or did he ever misuse grant of any parole? Did he surrender too much late?
You are denying that they ever threatened or harassed Bilkis Bano's family?
Absolutely not. This is all moonshine arguments.
Okay. I appreciate your joining us there, sir, and giving us your perspective, the counsel for the petitioners there. Thank you so much.